Let's move on to Trailer Bill number 826, drought submetering.
Okay. Trailer Bill 826 is designed to address the issue in California and thematically is tied in many respects with the diversion and use measurement requirements I discussed earlier, where we have many areas of California where you have multifamily homes. In particular here, we are talking about multifamily residences, not dormitories, not healthcare facilities, where you have water coming through a common meter and then distributed out to the individual users with no accountability for the individual users to know what their water use is and to be responsible for identifying what they're using and paying for it. So this would encourage responsible water consumption by providing residents with accurate information about the volume and cost of their water use, and that's two components of it, not just the volume of water they're using, but also what the cost is associated with it and what the landlord has historically been paying. It would require the measurement of consumption by the individual dwelling units in a newly constructed multi-unit residence through sub-metering. These requirements would come into effect for multifamily residential units constructed and receiving their water service connection permit after January 1, 2017. And it provides a framework for the landlords to pass on the cost of that sub-metering to the individual residences. Finally, it requires an update to the plumbing and building codes after the next cycle that begins after January 1, 2016 to provide notice to developers and local governments of the new sub-metering requirements, as well as to promote statewide uniformity on sub-metering.
So I'm a little bit confused by this one insofar as it, not insofar as it applies to new construction. I think that's quite clear, but how is it going to be applied to existing multifamily units? And I understand there's an exemption for affordable housing. Is that right?
Believe that is correct. I'd have to go back and check, but in general, it's
well. I'm going to have a follow-up question on that.
Okay.
When you do check.
In general, it is not going to apply to existing facilities. However, as this gets cycled through the plumbing code and the building code, I believe it was Member Obernolte and I earlier were discussing the issue of, when you have upgrades that trigger basic requirements within the plumbing code and the housing code, that would provide an opportunity for sub-metering to be required of those multifamily residences when they are upgraded after the plumbing code is updated to address those types of issues. So in other words, there would be a time and place over time for us to begin reaching the residential units, existing residential units.
I think it's pretty important for us to have a better understanding of what those circumstances are. I mean, just an upgrade to the plumbing code doesn't seem to me to give an opportunity for the type of infrastructure that would be required to sub-meter an apartment complex. With respect to the affordable housing, how are you defining affordable housing?
So actually, as I scan back through, I am not seeing this particular iteration of the trailer bill have a call out for affordable housing. And I think that's a reflection of the fact that the requirements as they stand in the trailer bill apply only to the new developments after January 1, 2017 that are pulling a water connection at that point in time. And again, for the existing facilities, it would be, to the extent that local ordinances requires they're updated, that they conform to any amendments to the building code or the plumbing code and the building code, that those would cycle through. So it wouldn't be as if new requirements would come into being on existing multifamily residences, whether or not it's for affordable housing or otherwise.
So ultimately, it sounds like it would be up to the local jurisdiction.
Correct, in terms of how they incorporate requirements to upgrade to satisfy plumbing code changes and building code changes. And normally that happens, of course, if there are updates to the building and permits need to be pulled from the local building departments.
I see Mr. Gordon shaking his head no, so I'm going to ask him to help clarify this so that I understand it better, rather than me asking a follow-up question. Mr. Gordon.
I was shaking my head no about something else, but so I don't know.
Well, then I'll ask my follow-up question if that's all right. What does it mean that when you say that under circumstances where there's an upgrade to the code, then local government has to act and implement submetering?
So a number of local ordinance, for example, when a property owner, multifamily property owner, or well, we'll just leave it at multifamily, come in and have to pull a new building permit because of some upgrade they're doing at the facility. Often there are requirements associated at that point in time that they would need to upgrade the facility in such a way to address any changes to the building code or the plumbing code that have occurred since the facility was first built. And so this would go through the process in the updates or updates associated with the property when they are pulling permits. And whether or not this would be specific provisions of the plumbing code or the building code that would be made applicable, local agencies have some flexibility in that regard.
Well, I think there's a lot of missing information there that local governments today need to know so that they understand what the administration is proposing to impose upon them through this trailer bill. Mr. Gordon?
Let me follow up this conversation, then I've got a different issue I want to raise. Are you suggesting, well, as I read this, it was my understanding that the state was going to require submetering in all jurisdictions. What you just said led me to believe that no, a jurisdiction would have some discretion as to whether they did submetering.
For new multifamily units pulling a connection, water service connection after January 1, 2017, there would be a uniform requirement statewide. How the submetering would be implemented for existing facilities would go through the plumbing code and housing code update process. And my understanding is that there's flexibility in that process to actually say, at the next time a building permit is pulled, that the facility will have to upgrade to reflect these codes, but also notwithstanding whether or not in the housing or the building code and the plumbing code that direction is given, local agencies would still have the discretion to require that as part of their local ordinances, irrespective of how the building code and plumbing code were updated.
Okay. My understanding is...
I will be honest, this is an area that, with respect to code requirements for the plumbing and building code, that at the Water Board we don't get into a lot. I'd be happy to follow up with more detailed answers for the committee members.
So I think I do have a question, though, that does relate to the Water Board. My understanding is that we're looking at these trailer bills because they're part of the governor's emergency drought response.
Right.
How do we justify, as an emergency response, something that relates to new construction after January 1st, 2017? That construction would therefore probably not be occupied until the summer of 2017, good 2 years from now. I mean, how does that relate to an emergency drought response?
Well, there are a couple different aspects of it. I mean, first of all, what we have learned both in our drought response over the last 2 years, as well as what the Australians learned, is you need to bake in the savings as quickly as you can. We recognize, and the trailer bill provides, this can be fairly disruptive, especially for projects in the process already. And so it provides an orderly transition period. And the reality is, we do not have a good sense of when this drought will end. Trying to build the process right now for water savings is an important component of it. And thematically, we feel that measuring is an important tool, and this just helps build on that.
Mr. Obernolte.
Thank you, Mr. Chair. I'd like to follow up on Mr. Gordon's question. We've been talking a lot about the what. I want to talk some more about the why, because I'm a little bit confused about the kind of water conservation that we're trying to incentivize here, because these are this is high-density housing, essentially. These aren't people with large outdoor watering structures. In fact, most of them aren't going to be watering landscaping at all. What kind of water savings are we hoping to achieve by installing these sub-meters?
Well, there are some of us over at the Water Board that are frequently heard saying you can't manage what you don't measure. And simply put, in a residential environment, when you are dealing with your own water use at your sink, your faucets, your washing machine to the extent they have them, showers, toilets, people don't have any real sense of what their real water usage is. And one of the things that's been striking throughout the drought is, a lot of local agencies providing bills to their customers have given them a much more clear portrait of where they stand relative to other water users. There's a lot. The biggest bang for the buck is no doubt in the landscape arena outside of the home. But inside the home, there's still wide variability amongst California water users in terms of people who take longer showers, leave the water running while they're at the sink, and having that signal that comes from a bill that shows you your volume of use. And one of the provisions of this particular trailer bill is to identify kind of what the standard is for a family of four. And so a renter in a newly sub-metered property would actually see kind of where they fall relative to what we expect the standards to be statewide. And so that's the utility from it. There is water to be saved inside, and frankly, at this point in time, most individuals living in a multifamily dwelling have no idea what their real water use is.
Okay. Well, my experience has been that most people are making decisions based on how it financially impacts them, and not necessarily by comparing themselves to what their water usage is versus other people. And unfortunately, or fortunately, someone in a multi-dwelling unit like this is not going to see a large increase in their water bill, even if they're a profligate user of water. So I'm just trying to weigh. I'm not arguing this is a bad thing, but I'm trying to weigh the benefits of it against the costs that we're going to impose on everyone in California in terms of higher housing costs. And that's what I'm struggling with.
Yeah, so the price signals are important, and certainly the sub-meters allow those price signals because it allows for the cost to be carried through to the individual tenants. But one of the most fascinating things about drought response, and that we've heard from some of the local agencies, East Bay Mud's been very good about this, is sort of report cards on how your own water usage is. And that can send an incredibly powerful signal. People like to compete with their neighbors, and they like to know whether they're doing worse than average or better than average. So it's a combination of the two, and sub-metering allows both of those conservation purposes to be served.
All right, thank you.
I know it looks like we have somebody else from the administration who wants to weigh in on this, but I want to make one additional comment, which you might wish to respond to also in your comments. It seems to me that the discussion about the water crisis is now running headfirst into a discussion about the housing crisis in California. Good conversation to have, good thing for us all to be talking about, but the LAO has recently released a report on the housing crisis, and the administration, at least when it comes to this particular issue, is providing a pathway to something that I personally believe is important. I think that ability to get that report card to understand what your own usage is very important. On the other side of that is the cost that this would bring to, likely bring to tenants throughout the state of California, many of whom, not just at the very low income levels, are faced with a crisis of affordability in housing stock in the state, and the administration has provided no funding or no signal that there is, and no signal that there's going to be additional funding to help defray some of those costs.
Yes, good morning. Randy Deems, Chief Deputy Director with Housing and Community Development, and Jim McGowan with the Building Standards Commission. We wanted to step forward to clarify about the process versus the local versus the state building standards. And I think Jim, as an expert in the process, can answer that question, and then we're available for any other questions.
Good morning, Mr. Chair, members of the committee. My name is Jim McGowan. I'm the Executive Director for the California Building Standards Commission, and I can offer some clarification as to the process for the Building Standards Commission. It's essentially a 2-year process when a state agency proposes building standards to the commission. It's a quite in-depth and very task-oriented type of process that we have. It includes a lot of public participation with respect to the vetting of the building standards. In the case of a building standard that's coming through on a normal process, it's going to go before our code advisory committees. We have 6 of those, and each is tasked with a different subject matter. Subsequent to that process, it goes through a normal 45-day comment period, much the same as regulations and other titles of the California Code of Regulations go through the Administrative Procedure Act. And then following on the heels of that is the Commission's meeting where we consider whether or not we're going to approve, disapprove, return the matter for further study to the state agency, or approve as amended. Again, it's a very lengthy process. Absent an emergency, it takes about 2 years for the building standards to become effective from the time that they are submitted to the Building Standards Commission for consideration.
What happens during that 2-year period of time that won't be happening if we pass this trailer bill language?
Well, again, if the state agency were to bring it forward as an emergency, the commission is required by law to convene within 30 days and hear the matter. And if they approve it upon filing with the Secretary of State, the building standard is effective. And then there's what's called a certifying rulemaking that occurs in order to make that building standard permanent. It mirrors the Administrative Procedure Act with respect to what the Office of Administrative Law does, administrative law. So during that period of time, and if we're talking about a 2-year period, that's where the state agency has created its building standard through a workshop process. It's submitted to the Building Standards Commission. It goes through, again, that Code Advisory Committee review process, and then is heard by the Commission. From the time that it is...
interrupt you if you don't
Sure.
mind. The certification process includes a workshop process. I assume the workshop process includes stakeholders, and you get stakeholder input during that
It does.
part of the process. And then you have advisory board process built in.
Correct.
Would it be correct that at that point in the process you're getting input from experts and those who have particular expertise that's relevant?
That's correct.
Right.
Where do you get that part of the process in what's being proposed by the administration?
Well,
How do you get it?
I would say that it's coming through. I'm not exactly sure where it falls in the scheme of things, but within the proposal, if there's the requirement that the material come before the commission for approval, it'll happen at that time. I mean, at this juncture, I don't know. I have to defer to HCD as to whether or not there has been any.
Looks like HCD wants to weigh in, so
Yeah,
please.
I think a key part of the question that we want to elaborate on is the requirement becomes effective to 2017. The locals will need to comply with it. So the relationship between what the locals will be doing in that period of time versus when the actual building standard comes forward. So, Jim, could you?
Not sure that that's responsive to my question, which is how does the administration propose to incorporate the kind of stakeholder and expert input that currently is part of the process?
I
In other
think
words,
that
this is how we make good regulations
right.
and avoid making mistakes. So how are we going to do that?
The locals will need to implement this, and then if building standards are required, to be implemented to provide, consistency and standardization. That is our role. That is a process that takes some time. Absent emergency regulations, that would take some time and be a deliberative process. But the locals would be implementing the requirements consistent with the date that's in the statute. And I think that's what we would like to provide some clarification of exactly how that works. And if
So are
Jim,
you saying that the equivalent opportunities for input from experts and other stakeholders is incorporated in the administration's proposal?
Yes. I mean, the expectation is that HCD and the Building Standards Commission will still go through their traditional process of establishing the code requirements. What the legislation essentially does is create fixed dates for the general requirement for submetering, the statewide consistency that will be provided by the code updates, and the requirement to consider the feasibility, which is one of the standards within, I think, both existing code provisions, but is explicit within the trailer bill language, is the kind of thing that they will address during their traditional code setting process.
right.
Have you given consideration to how this move to submetering in the existing housing stock will affect our many rent-controlled jurisdictions throughout the state?
I would have to get back to you on that.
Right. I'll take that as a no up to this point. Up to this point, the administration has not, but I think that's pretty important.
And I should be clear on that. It's very possible that it has. It's just within the purview of the
It's been
Water
part
Board.
of the discussions that you've been privy to. Understood. Any other questions? Let's move on to 827, groundwater well permits and the CEQA exemption for local ordinances.
Good morning. This is Chris Calfee from the Governor's Office of Planning and Research. Trailer Bill 827 addresses local ordinances for groundwater protection. Currently, counties regulate they issue drilling permits. Recently, some counties have adopted ordinances that would protect their groundwater resources by limiting export and a number of other measures. This provision would do two things. First, it would include findings language to clarify that local governments, through their police power to protect public health, safety, and welfare, may regulate groundwater. The second thing it would do would include a limited term CEQA exemption for local governments that adopt groundwater protection ordinances.
Are there any limitations on the authority that you're proposing here? For example, would it be limited to areas where the groundwater basin is in chronic overdraft, or any other criteria?
There are a number of limitations. First, there are time limitations. It would extend to 2017 or as long as the current state of emergency is in effect. With regard to the subject of the ordinances, it would address limitations on pumping and also limitations on the types of land uses that might be particularly high demand. The findings language does refer to, in particular, the highly stressed groundwater areas.
All right. Let's move on to Trailer Bill 830, the drought stormwater plans.
So Trailer Bill 830 is designed to address the acceleration of Proposition 1 funding, much of what you heard on Monday during the hearing. Most of the guidelines that are established for funding programs under Proposition 1 were contained within the text of Proposition 1 and included an expedited process that would exempt the adoption of the guidelines from the Administrative Procedures Act. Senate Bill 985 passed last year created additional funding requirements where local agencies, in order to get stormwater funds available under Proposition 1, would have to develop a stormwater resource plan. That stormwater resource plan must comply with guidance established by the State Water Board, and Senate Bill 985 had established a July 1, 2016 deadline for that guideline. Given the need to accelerate efforts to promote local water supplies, the administration has proposed accelerating stormwater funding under Proposition 1. In order to get that money out the door as quickly as possible, the administration is proposing to accelerate the process that the State Water Board can use to adopt these guidelines, and will use a process that's comparable, well, it's the exact process that's used for all the other funding guidelines under Proposition 1.
Questions? Mr. Gordon?
Yeah, so I understand the challenges and timelines related to the Administrative Procedures Act, but don't you have some other form of emergency rulemaking?
There is the ability to do emergency rulemaking. It would likely require an emergency declaration from the legislature, given the way that the Administrative Procedure Act was funded or was rewritten a few years ago to deal with the ability to use emergency regulations. But there's a more fundamental issue, which is the actual guidelines that the board would have to adopt here don't really lend themselves to regulatory language. It's the types of considerations and metrics that locals should use in developing their stormwater resource plan, and it doesn't fit neatly within regulatory language, because it's really more, these are the types of things that you should consider. So we felt that it was more appropriate, because this will be a trigger for financing under Prop 1, to use the Prop 1 analogs.
All right, thank you. Our next trailer bill is 831, the CEQA exemption for drought mitigations.
Yes, Trailer Bill 831 provides a limited CEQA exemption for drought relief projects. As background, the Public Resources Code does exempt certain projects that respond to disasters for which a state of emergency has been declared. It also includes an exemption for projects that mitigate or prevent an emergency. Courts that have looked at the definition of emergency have found that that does not include drought as a condition. So this provision would provide a CEQA exemption for certain categories of projects that are approved during a drought state of emergency. And those categories include connecting existing homes to community water systems, connecting community water systems to each other, the construction or expansion of stormwater infiltration and recycled water treatment facilities, the installation of recycled water pipelines within existing rights-of-way, and other measures that the governor might specifically identify in a drought state of emergency.
Thank you. Mr. Obernolte, why don't you start, and then I have some questions.
Thank you, Mr. Chair. So the proposed CEQA exemption for groundwater wells had a calendar sunset in addition to the state of emergency requirement, but this one does not. Can you talk about why this one doesn't have that?
Yes. The limitation in this provision is that the projects would need to be approved during an existing drought declaration. So not necessarily this particular, it would include this particular drought state of emergency, but also future drought state of emergencies that might be declared. And the reason for that is we have seen that droughts come in cycles, and so we anticipate that we will see future drought events.
So what was the rationale in putting the sunset on the groundwater well CEQA exemption?
Part of the rationale, I believe, for including the limitation on the groundwater ordinances was that the Sustainable Groundwater Management Act is currently beginning implementation, and so the regulation of groundwater protection ordinances may be folded into the Sustainable Groundwater Management Act implementation. That particular provision would allow for immediate action to protect groundwater resources pending those groundwater management plans.
All right, thank you.
This is potentially very broad. NOAA is estimating that the drought could last for decades. and that's been the experience in Australia. You just referenced the experience in Australia. So this is not I think something that has narrow applicability, and I understand some of the categories that it covers might be on the de minimis side, like connecting existing homes to water supply, and even connecting communities to one another. But when it comes to water treatment facilities and pipelines, these are potentially very large-scale projects, and just a blanket exemption from CEQA without a significant conversation, that seems like a long way to go here. Mr. Gordon?
Yeah, I think I would be far more comfortable with matching the language that we did on the wells and having some kind of a sunset, related to the current drought. If the drought continues, we've got a whole other set of problems to deal with in California, and we will have to come back and revisit some of these things. But this does feel a little bit too broad to me.
I also wanted to ask, what does the agency do, or the board do, with respect to these CEQA exemptions? What is their role?
Well,
in other words, is there a backstop to the exemption process, or is something categorically exempt and that's the end of it? And I'll just, by way of example, under the Coastal Act, the Coastal Commission staff has the ability, where there is an emergency like an earthquake or a landslide, to act to fill the breach when the emergency occurs, but they then have to go back to the commission and report on those actions. And so there is at least some oversight of what is otherwise an exemption type of process. Does anything like that exist in the governor's proposal?
It doesn't currently include a report back. The lead agencies would determine whether they fall within the scope of the exemption and would choose to apply it or not. That doesn't, in my mind at least, mean that there is no oversight, because many of these projects, particularly the larger ones, may require funding sources that require reporting back to the state board if they get state board funding, for example. Lead agencies have to go through their own Brown Act processes and others. This is just a limitation on the application of CEQA, not on the application of other laws.
And I think the only thing I would supplement from what Mr. Calfee said is, because you did ask about the water board process, as he indicated, this would apply to all public agencies that are undertaking one of these projects. But the example that Chair Bloom had mentioned with respect to wastewater treatment facilities or recycled water facilities, in order for those facilities to go forward, they need permits from the water board, whether it's a regional board or the state water board. They need both drinking water permit modifications as well as waste discharge requirements under Port of Cologne, both of which include a fairly robust suite of requirements for analyzing issues. And then I think what Mr. Calfee indicated, that a lot of these would depend on federal funding coming to them as well, and that carries with it environmental restrictions as well. So there are opportunities for those most largest projects, if you will, to undergo a public review process.
Well, I understand that, but and I accept and respect and understand the expertise of the water board as to the issues that it has expertise in, but the purpose of CEQA is to make sure that the full range of potential environmental impacts of a project, and particularly large-scale projects, are properly analyzed. I also understand that CEQA carries with it the potential for significant delays that one might legitimately argue are an impediment to addressing the drought. But there seems to be not much of a middle ground here to make certain that those issues of environmental importance that go beyond water issues are being given the opportunity for significant review. And so I have some concerns there. Any other questions? I think we have One left?